Hi, everyone. Thank you for joining us today for Constangy's webinar, Trump Rescinded Executive Order 11246, What's Next for Contractors? A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenter will leave some time to answer your questions. This program is approved for SHAM and HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenter, Cara Crotty.
Thank you so much, Victoria. Good afternoon, everyone, or good morning to our friends on the West Coast. Thank you for joining us today. My name is Cara Crotty. I am chair of Constangy's Affirmative Action OFCCP Compliance Practice Group, and I am also co-chair, along with my colleague Poonam Rogers, of our DEI Practice Group. And in my spare time, I'm an employment litigator here in Columbia, South Carolina. So I will be going through the materials today. As Victoria said, please feel free to submit questions in the chat. We do have a lot of information to cover, so I may save those to the end, or I might take a breather and answer some questions as we go along. But if I don't get the opportunity to answer them during the presentation, I'll try to follow up with people individually afterwards. And as I know, we still have some people coming in. As Victoria said, we will be providing the slides as well as a recording of the presentation afterwards. So I wanted to start this session with a couple disclaimers. The first is that I am a lawyer, and I may be the lawyer for many of you on the call, and certainly Constangy is probably provides legal counsel to many of you. But this is a very nuanced area, so I'm providing general guidance and information, but I wanted to make sure that you get specific legal advice around these topics for your organization, because obviously different organizations are going to have different priorities and different concerns. So that's caveat or disclaimer number one. Disclaimer number two is that there are still many unknowns or uncertainties around the DEI topics that we're going to be talking about today. So just keep that in mind, that we don't have all of the answers yet. So I might not be able to answer all of your questions today, but that doesn't mean that we won't have information or answers to those questions in the future. And kind of along the same lines, my third caveat is that what is true today may not be true tomorrow. This is a very rapidly evolving area. The government is, has been coming out with additional information and guidance and updates. So it's important that we keep those in mind as we go along in the future. And then fourth is that this is a politics-free zone. I always try to present information in a nonpartisan, unbiased way, even though some of these topics are, quite frankly, politically charged. But my goal is to provide information and be informative rather than to take sides on political topics. So hopefully I will be successful in doing that. Just real quick, an overview of what we're going to be covering today. Obviously, we'll be discussing Executive Order 14173, Ending Illegal Discrimination and Restoring Merit-Based Opportunity, which is the executive order signed by President Trump. How OFCCP is complying with the executive order and how that's impacted or affected contractors. The updates from DOL and OFCCP, continued compliance obligations that contractors have under Section 503 and VEVRA, things that contractors might want to eliminate or remove from their compliance scheme in light of the revocation of Executive Order 11246, voluntary measures that clients or contractors can continue to take in analyzing their workforce and employment practices, and then some final takeaways for you. So first, let's talk about the executive order that President Trump signed on January 21st, 2025. I am going to just go through what it says first, and then we'll kind of go dive into each aspect of it in a little bit more detail. The order, as I mentioned, was signed on January 21st, and apparently was very late in the evening that day. Many of you, I was kind of scrolling through the websites, the White House's website, to see what the new executive orders were. I went to bed not knowing that Executive Order 11246 was about to be rescinded, and I made the fatal mistake of checking my email in the middle of the night, which precluded any more sleep that night. But and so apparently it was signed sometime in the evening, but it wasn't actually posted to the White House's website until the next morning. But the text of the executive order says that its purpose is to ensure that the federal government enforces our civil rights laws by ending illegal preferences and discrimination. President Trump said it is the policy of the United States to protect the civil rights of all Americans and to promote individual initiative, excellence, and hard work. He therefore ordered all executive departments and agencies to terminate discriminatory and illegal preferences, mandates, policies, programs, activities, guidance, regulations, enforcement actions, consent orders, and requirements. He didn't want to leave anything out. So that was the purpose of Executive Order 14173. There are a lot of different components to that executive order. We will obviously today be focusing on the section that revoked Executive Order 11246. So 11246 has been around since the 1960s when President Johnson initially issued it. It's been updated and amended by several presidents during the years. But that was specifically and unequivocally revoked by President Trump. In the executive order, the new order, President Trump provided that federal contractors could continue to comply with the existing regulatory scheme for another 90 days. OFCCP was directed to immediately stop promoting diversity, stop holding federal contractors responsible for taking affirmative action, and stop allowing or encouraging contractors to engage in workforce balancing based on race, color, sex, sexual preference, religion, or national origin. The executive order also imposes some new requirements for federal contractors. The head of each agency has been directed to include in every new contract or grant award 2 items. One is a term requiring contractors to agree that their compliance with federal anti-discrimination laws is material to the government's payment decisions. And 2, also a term requiring the contractor to certify that it doesn't have any programs promoting DEI that violate the federal anti-discrimination laws. So that's all it says about DEI for federal contractors. And I've seen some reports where there's been the blanket statement. So all DEI is unlawful, or federal contractors can no longer have any DEI. I think that's an overstatement, certainly. DEI, first of all, is not defined in the executive order. And, DEI means a lot of different things to a lot of different organizations. So I think that blanket assumption that DEI is now unlawful is not technically accurate. So let's unpack that, the new executive order. Let's go through the sections that I highlighted for you and walk through what it really means for federal contractors. First of all, I wanted to take a look and show you what Executive Order 11246 actually says or said, and what the regulations say. Executive Order 11246 was specific that federal contractors could not engage in discrimination on the basis of protected characteristics, race, color, religion, sex, or national origin. President Obama added sexual orientation and gender identity to the categories of protected characteristics while he was in office. But the EO clause that the government was required to place in all covered federal contracts, and that then contractors were required to flow down to its subcontractors or their subcontractors, is the language here on this slide, which says that the contractor won't discriminate against individuals based on those protected characteristics, and that they will take affirmative action to ensure that applicants are employed and that employees are treated without regard to those protected characteristics. And then with respect to advertisements for job openings, contractors were required to specifically state that applicants would receive consideration without regard to those protected characteristics. The regulations implementing the executive order also speak to these issues. The affirmative action plan requirements note that the AAP is a management tool that was designed or was created to ensure equal employment opportunity. In the section of the regulations regarding the development of placement goals, so placement goals were where contractors would set goals for females or minorities where representation of those groups was statistically significantly different than the estimated availability. But even if a contractor set a placement goal, the regulations were clear that that would not provide the contractor with a reason or a justification for setting a quota, which was expressly forbidden, or for setting aside positions for females or minorities, or creating a preference for females or minorities. Those were specifically prohibited by the regulations, and the regulations made it clear that contractors should always hire the most qualified candidate without regard to race or gender or any protected characteristic. So that's what the executive order and the regulations actually said. The new executive order had a provision stating that contractors could continue to comply with the regulatory scheme for 90 days. If you were like me, you might have scratched your head about what exactly does that mean. I still am not entirely sure of the import of that statement, because what was lawful under Title VII prior to January 21st is still lawful today. Title VII hasn't changed. So what contractors were doing to comply with Executive Order 11246 and its regulations was completely lawful, as long as you were complying with the executive order and the regulations and complying with Title VII. So I have interpreted this to mean, of course, if you read the rest of the executive order, there's this presumption that contractors were violating Title VII and violating anti-discrimination provisions in connection with their compliance. And I think if you are operating under that assumption, then this provision basically gave contractors some grace period to come into compliance. That's how I interpret this, but I could be wrong. So let's look at the 3 directives that the president gave to OFCCP. The first one was to stop promoting diversity. So diversity isn't defined in the executive order. 11246 wasn't defined or used in the regulations implementing Executive Order 11246. And so diversity is not something that the OFCCP has ever had authority over. We have seen the past few years, the agency, excuse me, was promoting and advancing diversity as a benefit for contractors. So presumably the OFCCP is removing and scrubbing references to diversity in its outward-facing materials, but it's never been part of the compliance scheme at OFCCP. The second directive was to stop holding contractors responsible for taking affirmative action. So presumably that's related to affirmative action under Executive Order 11246, which no longer exists. But it is important to note that contractors must still comply with Section 503 and VEVRA that do have affirmative action quote unquote obligations. And we're going to talk about that in just a bit, in a few more minutes, go into detail what those obligations are. And then the last directive was to stop allowing or encouraging contractors to engage in workforce balancing based on race, color, sex, sexual preference, religion, or national origin. Of course, as we just went through, workforce balancing was never a requirement or purpose of Executive Order 11246 or the regulations. Certainly, we were measuring our workforce and analyzing our demographics, but ultimately achieving the perfect balance was never a requirement. So I'm not sure there's any really much impact on OFCCP based on that final directive, other than we're just not enforcing the executive order anymore. And let's look at the future contract requirements. Like I mentioned, the two new terms agreeing that compliance with anti-discrimination laws is material to the government's payment decisions, and that we're certifying that we don't have any illegal DEI. So I think the important thing for contractors to remember is that we can only be held accountable for the terms in our existing contracts. This is all through the operation of contract provisions and contract law. So the president doesn't just have a magic wand that he or she can wave and say, all federal contractors now must do X, Y, and Z. Until we have a contract that actually includes a requirement to do something or not do something, then none of these requirements will actually apply to any given organization. Think back to COVID and the contract clause that President Biden, his executive order requiring federal contractor employees to get vaccinated. Again, that requirement would not have applied to contractors until they had a covered contract with that term. And typically when there's going to be a new contract clause, the government will go through kind of the standard administrative process of developing that clause and vetting it through notice and comment and getting OMB approval before actually inserting them in contracts. But I don't think that's happening here. There's no directive in the executive order to promulgate regulations, specifically directs the agency heads to include the contract terms. And thanks to a client yesterday, I saw actually, I believe it was a grant that they had received, a new grant that does include the provisions, and they seem to have been lifted verbatim from the EO, from the executive order. So there are lots of questions around how that's going to be implemented, those two contract clauses. So how are we going to determine compliance with anti-discrimination laws? What if we have an EEOC charge? Or what if the EEOC issues a cause determination? The EEOC, if they determine a company's not in compliance with something, how does that affect our statement that we are in compliance, or our agreement to remain in compliance? What if the EEOC files an enforcement lawsuit? What if there's a private litigant that files a lawsuit alleging a violation of the anti-discrimination laws? How is that going to play into this analysis? And under what circumstances will the government decide that payment should be denied? How are they going to enforce this? How do we contest the government's determination if they should decide payment should be withheld? And then, like I mentioned, is there going to be one standard clause or clauses that all the agencies are using, or are we going to be seeing different clauses from different executive agencies? For the certification, who's supposed to certify? And how do we certify? Are we certifying just by entering into the contract? How is DEI defined? That hasn't been specifically outlined by the government yet. What does promoting DEI that violates applicable federal anti-discrimination laws mean? What does it mean to this administration? How are they interpreting that? Another big question, you've probably seen comments and concerns raised that this could potentially raise liability concerns under the False Claims Act. If we're certifying to the federal government something that to be accurate, and we're acknowledging that it's material to the government's payment decisions, then arguably this will raise potential False Claims Act liability. Is the government going to set up some kind of hotline for whistleblowers to report alleged violations? So again, kind of the same questions around both of these terms. I see some questions here, so let me take a minute to see if we can run through some of these. Some of these, if I don't answer it, it means I'm probably going to get to it in the future. So for grantees, the executive order, the question is, how about for grantees? Does this apply? The questions around these contract clauses do apply to grants as well as to contracts. Here's a question. Why were placement goals ever used? I'm trying to understand the purpose when quotas were considered illegal discrimination. So the purpose of placement goals were for contractors to understand if there were segments of its workforce where there might have been barriers to equal employment opportunity. So if we look at our existing demographics and we compare it to census data based on the types of jobs we have and where we're located, are there significant differences between what our workforce looks like and what you would expect it reasonably to look like? And when that occurred, we would set placement goals, and that told contractors that, we should probably do some additional recruitment efforts to attract females and minorities to our organization. That really was the whole theory and purpose behind the executive order in the first place, 11246. The whole theory was that federal contractors are required to go out and affirmatively recruit females and minorities to their organization, creating this diverse candidate pool. Then through application of their neutral, non-discriminatory selection process, over time, the workforce will become more diverse as well. So it never abrogated the non-discrimination principles. It was really just a way for contractors to see if there are maybe barriers to equal employment opportunity for different demographic groups. Grantees did not have affirmative action obligations under Executive Order 11246. So only federal contractors were required to comply with the executive order in developing affirmative action plans. Some grants might have had different types of EEO and non-discrimination obligations, but not the formal requirements for written AAP to comply with Executive 11246, and the OFCCP would not have audited someone that just had a grant. Here's a good question. What if we are currently negotiating a federal contract that includes compliance with 11246? Probably it's going to depend on, is this a direct contract with a federal government or with or if you're a subcontractor negotiating with a direct contractor. I would definitely raise the issue because we do have two issues here. One is, what is the federal government enforcing? And two, what are we agreeing to do by contract? And I don't think at this point anyone is intending to create contract obligations around the executive order, given the government's abandonment of this. So I would definitely suggest going back either to the contracting officer, if it's with the federal government, or to the company that you're negotiating with and saying, we need to strike this language since it's no longer applicable or required. Going to get to questions about the EEO1, so hold off on those thoughts. Here's a question. We are a contractor only due to our FDIC insurance. How does this apply given that we don't have other contracts? I think the same principles apply if you're talking about the contract terms. That's a good question. And I think that's one that I don't have an answer to yet, that we're going to have to wait and see for further guidance and clarification. Like, I think that goes to how is this going to be enforced? You know, if you don't have a specific contract that you're entering into that it contains or includes these terms, that raises some questions. Is there a requirement that government contractors cannot use pronouns and email signatures in their correspondence with the federal government? I have not seen that as of yet. I believe the federal government has scrapped the use of preferred pronouns in their emails and other designations. But that hasn't impacted what federal contractors or private companies have the right to do. And I don't think that they would, should you choose to, at least at this point, again, what's true today might not be true tomorrow. But if you continue to allow your employees to express their pronoun preferences, I don't think that the government would have the ability to prohibit you from doing that in your communication with the government. Is this going to do away with set-aside contracts for female and minority-owned businesses? I suspect that's on the Trump administration's agenda. I haven't seen anything specific about that other than the general directive to do away with DEI-focused initiatives. Lots of good questions. Will completing the utilization analysis still be required for certain contracts? Not for females and minorities, at least not on I wouldn't think on the federal level. One thing we're going to be talking about is there's still going to be state contractor requirements where some of these same analyses are required. Should the term affirmative action no longer be used? Not necessarily. Affirmative action with respect to females and minorities on the federal level is now gone, and I would probably eliminate it to that extent. However, as I mentioned, we still have to comply with Section 503 and VEVRA, which do have affirmative action obligations. And you might have obligations on the state or federal, or the state or local level as well. All right, I'm going to stop doing questions for a little while and pick back up. But really lots of good conversation points here. So on Friday, after the president's executive order, the acting Secretary of Labor issued an order stating that the DOL no longer has authority under the rescinded Executive Order 11246, specifically directing to OFCCP, the Office of Administrative Law Judges, which handled the administrative complaints filed by OFCCP, and then the Administrative Review Board, which reviewed the recommended decisions of an ALJ under the executive order. And the acting secretary announced that the department would stop investigating or enforcing anything under the executive order. So any pending compliance evaluation, complaint investigation, conciliation agreement, anything with respect to 11246 was done. And the order directed the OFCCP to notify all contractors that had an open review or investigation that the 11246 component was done, closed, and that the components related to Section 503 and VEVRA would be held in abeyance pending further guidance. And that communication was to take place by January 31st. I will say most of all of my clients, but one, received that notice on that day, many late in the day. But they all came out. I got one notice the following Monday relating to a complaint investigation. So as far as I'm aware, the OFCCP did comply with that directive. The OFCCP's website has pretty much been scrubbed. There is a notice there directing or just informing contractors that the website's being revised to come into compliance with the new executive order. Still includes the link for individuals to file a complaint under Section 503 or VEVRA. It also includes a link for the help desk if you have questions. However, I will say I tried to use it to see what happened, and it took you to the complaint form. So it wasn't necessarily very helpful. Everything on the website has been scrubbed. It's virtually non-existent. If you try to navigate to some of the even Section 503 or VEVRA information, you can't get there through the OFCCP's landing page. It basically gives you this generic set of links for DOL in general. However, I did find that you can still navigate to some of the existing information just by using a search engine and finding the link. So it's still out there. You just can't get through it through the OFCCP's landing page. Michelle Hodge, who was the director during the Biden administration, is now deputy director, and Michael Schloss has been named the acting director and deputy director for policy. He was formerly with the Department of Labor's Employee Benefit Security Administration, which basically was the agency that was responsible for protecting employee benefit plans and enforcing ERISA. I'm honestly not sure what his background, if any, is in equal employment opportunity. But other than that, we have not heard anything from DOL or OFCCP to date. The silence has been a little bit deafening given the upheaval that we have had in this space. So obviously the agency has a lot to work through right now and is dealing with many internal challenges. So hopefully we'll get more guidance in the not too distant future. Lots of questions about Section 503 and VEVRA in the chat. So just a reminder that contractors do still have to comply with Section 503 and VEVRA. These were statutes that were enacted by Congress and that therefore can only be repealed by an act of Congress. And we know how difficult that is these days, so they will probably remain in place. But Section 503 requires contractors to take affirmative action to recruit individuals with a disability, prohibits discrimination, requires reasonable accommodations. VEVRA prohibits discrimination against protected veterans and requires affirmative efforts to recruit protected veterans to the workforce. Both of these laws have a pretty complex regulatory scheme. We focused on the executive order and its requirements for so long because they're equally complex. And we also know that's for contractors where we were most likely to see monetary liability during an OFCCP compliance evaluation. But there's still a lot going on with Section 503 and VEVRA. We still have to develop our annual written affirmative action plans, including the data analyses that are included in that. Our utilization analysis of individuals with a disability, that's as of our snapshot date. Our annual hiring benchmark for protected veterans. So that includes our hires and our competitive promotions during our plan year. The data collection analyses for both individuals with a disability and protected veterans. That includes a lot of our employment activity information. Our applicants, our hires, promotions, and transfers all have to be counted in that component. We still have to list our job openings with the state unemployment agency. That's a specific requirement of VEVRA. We have to include the tagline in our job ads stating that we're providing equal opportunities for disabled and vets. We have to engage in those good faith recruitments and evaluate the effectiveness of those recruitment efforts. That's been a big focus of OFCCP the past couple of years. We still have to provide the opportunity to voluntarily self-identify disability and veteran status to applicants, to new hires post-offer, And then for employees, we have to invite them or give them the opportunity to self-ID disability status at least every 5 years with an interim reminder in between those 5 years. And of course, for disability self-ID, we still have to use the form that OFCCP has provided that has been approved by OMB. But wait, there's more. We still have to obviously provide reasonable accommodations to individuals with a disability. We have a mandatory policy statement. Training for personnel involved in making employment decisions. That's been a requirement under Section 503 in VEVRA. It actually was not a requirement of the executive order. Have to include our EO clauses in covered contracts and purchase orders. We might be revising that EO clause, like I mentioned, but Section 503 and VEVRA have actually very specific language that if you're incorporating it by reference, that must be included. We still have to notify our subs and our vendors, our unions, regarding our affirmative action policy and request their cooperation. Reviewing personnel processes, assessing our physical and mental qualification standards, designing and implementing audit and reporting systems, our action-oriented programs, and we still have record-keeping obligations. Honestly, most of the record-keeping obligations that were required by the executive order are still going to be required under Section 503 and VEVRA. We still have to keep records of all those personnel actions and decisions. Some questions, though, about Section 503 and VEVRA enforcement. We have uncertainty here. What's going to happen with those existing compliance evaluations that were paused? All we got was the notice that, hey, these are held in abeyance and we'll get back to you later. So what's going to happen? What's going to happen with the existing corporate scheduling announcement list? A lot of contractors on that list never received a scheduling letter. So is the OFCCP going to come back to those lists and schedule Section 503 and VEVRA reviews, or are those going to be abandoned? When is the OFCCP going to revise the scheduling letter and itemized listing? It would seem to me it would be necessary to do that since it's replete with references to the executive order. I don't think they can issue that and just say ignore those other things. I think they'll have to go through the normal notice and comment period to make changes. So if that's the case, I wouldn't expect any new audits, new scheduling letters or audits to be initiated for some time. And then we know that OFCCP still has enforcement authority under Section 503 and VEVRA, but what is that going to look like in the future? Are they just not going to bother? Are they, will they even do compliance evaluations? Or, from one extreme to other, are they going to do on-sites with every single compliance evaluation? There's a broad range of potential future enforcement efforts. So everything from doing nothing to full-blown on-sites and compliance reviews. So obviously we don't know. So a lot of questions in the chat about annual reporting. The VETS 4212 report has not been affected. It's a different statutory requirement. So September 30th, absent other changes or announcements, that report will still be due. Our EEO1 report, that's a requirement of Title VII from the EEOC. So that, again, absent other changes, it will continue. However, there is that little carve out there for contractors that have 50 to 99 employees were required to file the EEO1 report. I'm assuming that will be eliminated and that won't be required. So the EEO1 report would be limited to private employers with 100 or more employees. We haven't heard any announcements from the EEOC regarding the filing this year, when the portal will open, when the deadline will be. So that remains to be seen. We do know that the past few years, the EEOC has allowed us to annotate our EEO1 report to include information or the numbers of non-binary employees. I suspect that might not be an option anymore, given the administration's position regarding sex. There only being two sexes. And perhaps the EEOC will update its guidance around voluntary self-ID to say we should only be asking for male or female. Another big question is about the OFCCP contractor portal. The agency instituted that requirement a couple years ago that contractors certify on an annual basis that they have AAPs in place. Well, we're still required to have our Section 503 and VEVRA AAPs, so will the agency continue that certification for those plans? Obviously, no announcement has come. Perhaps they will keep that. Perhaps the time frame, which has typically been the beginning of July or end of June, will change, but we don't know. All right, so let's talk about some changes that will impact contractors because of the rescission of Executive Order 11246, as well as some things that contractors might want to continue to voluntarily do. So some things that contractors should probably be looking at eliminating are references to the executive order where you can. Again, if you have existing contracts in place, the contract language is what it is. Just know the government's not going to be enforcing that. But a lot of us will have references to the executive order in our policy statements, our manuals, on purchase orders that we routinely issue, maybe in our tagline for job announcements. So I would keep an eye out for references to that because that's now obsolete. You might have references to your affirmative action plan for females and minorities. Again, that's no longer necessary for federal contractors. Keep in mind, however, that you might have state or local laws that require a affirmative action plan for females and minorities. Several states, if you contract with a state agency, will have affirmative action requirements. And then you might have affirmative action. You might use the term affirmative action in general. I suggest that you limit that to groups, to only our individuals with a disability and protected veterans, to eliminate confusion about what we're talking about in our policies and procedures. Again, unless you have a state or local requirement that dictates otherwise. What actions are still lawful for federal contractors? Well, there are obviously a lot of things that we're no longer required to do under the executive order. But like I mentioned at the beginning, if it was lawful and consistent with Title VII principles before January 21st, it's still lawful today, unless until the EEOC either changes their guidance or a court rules otherwise. But such things as recruiting a diverse pool of candidates, providing the voluntary self-ID for race and gender to applicants, analyzing our employment activity for adverse impact based on race and gender, comparing our workforce demographics to availability estimates, evaluating our compensation for disparities based on race or gender. Those were all things that we were doing specifically for compliance reasons, but there's nothing that prohibits contractors from doing those, or any employer from doing these. And I have a note here about the Uniform Guidelines on Employee Selection Procedures. So this is the EEOC's guidance. It applies to all employers, not just contractors. And these have been on the books since, I think, the 70s, a long time. But they provide that employers that use a selection procedure that has an adverse impact based on a protected characteristic should cease using that selection procedure unless it's been validated. The guidelines also state that employers should maintain records that will allow it to evaluate whether or not its selection procedures have an adverse impact. So if we aren't collecting race and gender from our applicants on a voluntary basis, and if we're not analyzing that activity, it's going to be difficult to do that assessment to see if there's a barrier to equal employment opportunity to any race or gender. So certainly, again, at this point in time, all of those things are completely lawful, and it's up to a contractor to determine for themselves whether or not they want to continue doing that. I will say that, the advantage now, since it's not a technical regulatory requirement, that these types of analyses can be done under privilege for the purpose of obtaining legal advice, rather than just to comply with the OFCCP regulations. So, kind of on the flip side of that, the things that contractors may eliminate. Remember the pay transparency statement that we have? OFCCP issued a poster that we were required to post, statement that we were required to put in our policy manuals. That's no longer required because it was a component of the executive order. But be aware that the National Labor Relations Act would also prohibit contractors in most instances from disciplining employees for discussing compensation. That's considered protected concerted activity. We might not need to have a written policy around it, but we would already be prohibited from taking those kinds of adverse action. We might not need or desire to take targeted recruitment towards females and minorities anymore. Again, we don't have to take or provide the voluntary self-identification option on race or gender for applicants. But again, remember, we have the uniform guidelines, and we might have state or local laws or contract requirements that would make it a good idea to continue requesting that information. Same for analyzing our employment activity and comparing our workforce demographics and evaluating our compensation. So it's really up to each organization to make that decision on whether or not they want to continue to do those analyses. Many companies find that information extremely valuable and informative, and they don't want to lose the practical insight that it provides and the way that it helps mitigate risk. I think a lot of organizations feel that just putting your head in the sand and ignoring these types of issues may not be the best approach for helping to mitigate risk. All right, what's next? The Attorney General's report. President Trump's executive order directed the Attorney General to report out on recommendations for enforcing civil rights laws and other measures to encourage a private sector to end illegal discrimination and preferences. And I think encourage there is with a stick, not a carrot. But specifically, the president wants to know examples of the most egregious DEI discrimination practices, steps to deter those principles, and each agency is requested to identify 9 alleged violators and targets for potential litigation. So those measures this report from the AG is due back by May 21st. So I'm sure that will be exciting reading for everyone. In the meantime, the Attorney General did issue a memo last week to the Department of Justice, stating that it will investigate, eliminate, and penalize illegal DEI preferences, mandates, policies in the private sector and in educational institutions that receive federal funds. And the memo stated that encompasses programs, initiatives, or policies that discriminate, exclude, or divide individuals based on race or sex. And I get what discriminate or exclude mean. Divide, I'm not so sure. I mean, that can have multiple interpretations. Are we talking, physically separating, segregating? To me, that's kind of the same as exclude. Maybe it's different if we're just segregating. But divide could also be interpreted to mean, figuratively, or like along ideological lines. So I'm not sure what divide means in that context. But the memo did make it clear that they were not prohibiting educational or cultural observances or celebrations, as long as they didn't engage in exclusion or discrimination. We've already seen at least one legal challenge to the executive order. This was filed in Maryland District Court, I think a week ago, maybe 2 weeks ago, by a variety of associations and the City Council of Baltimore. And interestingly, I'm running out of time, but as a side note, apparently a lot of these challenges are being filed in Maryland federal court, because most of the sitting judges there, the active judges, were appointed by President Biden or Obama. So I'm thinking they're guessing they'll get a more friendly reception. But the arguments here against the executive order challenging the constitutionality of it are multifold. Here we've got the First Amendment. It's infringing the freedom of speech rights of these public or private companies around DEI policies and initiatives, telling them what they can't say in their own company. Violating the Fifth Amendment, the right to due process, because it's unconstitutionally vague. It doesn't tell companies, doesn't provide sufficient clarity around what exactly it's prohibiting, what is illegal DEI. And then it also allegedly violates the separation of powers doctrine, because it's infringing or usurping Congress's right to decide how federal funds are spent. So those are the allegations. Obviously, we will keep a close eye on this lawsuit and any other legal challenges to the executive order. So how should contractors and all employers really prepare, knowing that the administration is targeting our DEI policies and practices? First and foremost, I think, would be to audit any and all policies or practices that you have relating to DEI. And by that, I mean, it doesn't have to have the DEI label or name on it. DEI can include a lot of different types of programs or initiatives. So you really need to keep a close eye on your external communications, whether it's on your website or in your annual reports. Anything outward facing that talks about preferences or providing benefits to individuals based on race or gender, I think need to be very closely scrutinized. Certainly you might want to consider renaming or relabeling your DEI initiatives. Obviously just the word the phrase diversity, equity, inclusion, DEI has become a loaded term. So if we can avoid potentially scrutiny just by renaming something, then certainly that's something to consider. However, it's the substance that really matters, regardless of what you're calling it. So definitely remember that. I don't think we're going to be off the hook just because we call it something else. Stay tuned to DOJ and EEOC for any updates and guidance that they provide in this area. And I would pay particular attention to the policies and programs that we have already seen challenged, really since the Supreme Court's decision in the Students for Fair Admissions case in June of 2023. We've seen a plethora of lawsuits challenging a variety of different employment actions or policies. The ones I've listed here, I think, are the most notable ones: scholarships, training, mentorship programs where eligibility is conditioned on race or gender, or an apprenticeship program where we have set aside a position for someone and their participation in the apprenticeship program is based on race or gender. Any types of goals or targets that we have set around diversity that could be interpreted as we will achieve this or we must achieve this. You know, aspirational goals and objectives have always been okay as long as that's truly what they were and we didn't have mandates in place for achieving them. And I think now in this environment, even just the language using goals or targets, it's easy to be misinterpreted or misconstrued. So definitely look at those with a microscope. Incentives based on attainment of diversity metrics, I think creates an inference that impermissible motives may exist in making employment decisions. Diverse slate policies where we say we're not going to send our slate of candidates to the hiring manager unless it includes X number or percentage of males or I'm sorry, females or minorities. That generally will likely mean that race or gender would be a factor in people moving forward in the selection process. Employee trainings that could be considered harassment. Most of the lawsuits we've seen in this area have not gotten very far. Employers have been successful in defending their equal employment opportunity training, their non-harassment training, their DEI trainings, their unconscious bias training. They really don't rise to the level of harassment, but if they include any components that have been really targeted, like critical race theory or white privilege or things like that, that could create controversy, I would certainly look at those. Our LGBTQ issues, a lot of unknown in this area given the administration's executive orders, like the bathroom access. I don't have 5 minutes left, so I don't have time to get into everything that's going on at the EEOC, but certainly that's an unknown area. The use of pronouns we touched on earlier, and non-binary self-ID. And then finally, offering board membership to individuals based on race or gender, saying our board must look like this. I think that could be a problem under Section 1981. So obviously, we've got multiple concerns at play here. We have what the law says. We know what Title VII says, how it's been interpreted by courts to date. We know what the EEOC's existing guidance around Title VII is. So that's one thing. But then we also have how is the administration interpreting these things, which may be different than what the law currently says or what the existing guidance is. And then we also have public opinion around all of these issues. So lots of competing and sometimes conflicting priorities. And so it makes this very difficult and challenging to navigate. I wish I had more advice to give around that other than just to stay tuned and remain aware of the new developments. And then we'll close with my top 10 unanswered questions, things that we hope we get guidance around in the near future. So how will we certify that we don't have illegal DEI practices? Again, is this going to be kind of like the OFCCP contractor portal? Is there a place we're going to have to log in and certify on an annual basis? Or just how will that be implemented? What does illegal DEI mean to this administration? They have not technically defined it. Right now, I'm interpreting it to mean things that are unlawful under Title VII. How will the requirements in the new executive order be implemented and enforced? How are they going to enforce the certification requirements? How is OFCCP going to enforce compliance with Section 503 and VEVRA? How are establishments defined under Section 503 and VEVRA? I think I saw a question in this about this in the chat. So Section 503 and VEVRA don't have the same regulatory scheme around our establishment structure and rolling up the smaller locations with employees that have less than 50 employees into a larger establishment. I don't believe that they have the same provision that we had in the executive order regulations about creating FAPs. So how is the OFCCP going to approach existing or future FAP agreements? We don't know. When will OFCCP revise the scheduling letter? What's it going to look like? Will the OFCCP still use the existing CSALs for future audits? Will we still have the contractor portal certification? Is the government going to set up a whistleblower hotline for employees or anyone to report alleged DEI violations? Will President Trump issue another executive order impacting contractors? Is something else going to come down the pike? And then finally, will OFCCP cease to exist altogether? Contrary to some representations, that hasn't happened yet. Actually, I saw an e-blast from the EEOC that said the president's executive order resulted in OFCCP ceasing operations. That's not a true statement. I mean, they might not be actively auditing companies at the moment, but they still have enforcement obligations. So Who knows what will happen in the future regarding how they intend to continue enforcing contractors, though. However, I'm certainly suggesting to my clients that remaining compliant with Section 503 in VEVRA is still a good idea, and it's still the law. So in sum, there's a lot going on. Hold on to your hat for the next, certainly at least few months, maybe few years, until the dust settles and we have a little more certainty here for contractors and employers in general, especially around these DEI issues. So I know we're at the top of the hour. I'm going to stay on and go through the chat questions. If I didn't get to your question, you're welcome to email me. And I know most importantly for many of you, you want the SHRM and HRCI codes. So here those are. And again, if you missed us at the top of the hour, Victoria will be emailing both the slides as well as the recording of the webinar to folks in the next day or so. So for those of you that want to hang out, you don't have another call to get to, you're free to do so. Victoria, I'm assuming I'm okay to stay on a little bit longer.
Yes, absolutely.
Okay. All right. So let me scroll back up here and get to some of these. I think I answered some of these. So bear with me as I read through them. Sorry if it might take a minute. Get back to where I left off. Okay. So does the affirmative action believe that DEI is a form of does the administration believe that DEI is a form of affirmative action and thus the revocation? I mean, it's a little bit hard for me to interpret or speak for the administration. What I think is that there was a misunderstanding around what the executive order required and what federal contractors were doing. Certainly, if you read the President Trump's executive order, there's clearly the assumption that there were unlawful preferences and illegal, reverse discrimination occurring. So I think that's the impetus for that. I've addressed some of that. How will this impact the annual AAP preparation? That's a really good question, and then that's going to depend organization by organization. You obviously still have to comply with Section 503 and VEVRA, so those plans are required on an annual basis. And honestly, for the way we develop affirmative action plans, it's not going to impact the overall amount of time required in a very significant way, because we still have to include all those different data components like I laid out in that slide. We still have our workforce snapshot data, our applicants, our hires, our promotions, our transfers, our terminations are really the only thing that we don't need anymore. And I feel it's always important to reconcile that data to make sure it's accurate. If we're going to be reporting on it, we want to make sure it's correct. And that's always the most time-consuming part of plan preparation on our end. So I don't think really it's going to impact contractors all that much. Will we still be required or allowed to track EEO demographic information for employees and applicants if we are a federal contractor? Yes, I think I touched on that. So we still need to, all employers with 100 or more employees have to ask their new hires to self-identify race or gender. So that hasn't changed. Now you have that question about for our applicants, whether or not you are going to continue doing soliciting race or gender information. So is there a new tagline we should use? It depends on what you were currently using. You had some options before as to what exactly your tagline said. So you no longer have to reference the executive order. You don't have to reference the protected categories under the executive order: race, color, religion, sex, national origin. However, you do still have to say or reference disabled and vets. So I think if you were using the shortened tagline, we're an equal opportunity employer, including disabled and vets, that should be sufficient. I think that's the same. We were previously required to use certain language in our vacancy announcement that we are an affirmative action, equal employer, equal opportunity employer, and encouraging certain applicants to apply. Can we still do that voluntarily? Yes, I would probably not use the affirmative action label anymore, just from a perspective and optics standpoint. And I probably wouldn't say candidates of a certain race or gender are encouraged to apply, just again, because of optics, but that it would not technically be unlawful based on what we currently know today. I think I've addressed all of this. Yes, you'll be getting a copy of the slides. Oh, this is a good question. If a federal contractor has to certify that it is not engaged in DEI practices, how can they enter into state or local contracts that require it without violating their federal certification? I suspect there's not going to be that much of a conflict here. On the federal level, we're certifying that we don't have unlawful DEI practices. And I suspect and think that the state and local requirements should be consistent with Title VII. So they might still have quote unquote affirmative action obligations where we're analyzing our workforce, engaging in good faith outreach efforts. But doing that, I don't think would technically, mean that we're have unlawful DEI. So again, you need to look at those things closely, and there could potentially be a conflict at some point between what you have requirements on the state or federal or local level versus what the federal regs require. A question about the uniform guidelines. I don't have that site on the tip of my tongue, but if you Google the uniform guidelines on employee selection procedures, just look, there's a section in there on data collection and information and analyzing the information. So it should be pretty readily available. Is there a risk to continue outreach for organizations that we use for race or gender purposes? So I don't think at this point, the EEOC's existing guidance says that using diverse recruitment sources is perfectly fine. It's okay to do targeted recruitment. I think as long as you're not doing that exclusively, certainly, that continuing to target recruitment sources that will refer females and minorities and individuals with a disability and protected veterans, I think should still be okay. But I would put this in the category that is a little bit of an unknown because we don't know what approach this administration is going to take on that. Existing guidance would indicate that it's fine. Again, if it was lawful before January 21st, it's still lawful today. The principles of Title VII haven't changed. Definitely sending out the presentation. And we also post a link to it on our website, so you can always go to our event or our resource page for that. Is it legally okay to have candidates and employees fill out an EEOC form for data information. You're talking about the voluntary self-identification form. You still definitely want to do that for your new hires because you have your EEO-1 reporting obligations. Remember, we still have to provide our new hires the opportunity to self-ID their disability and veteran status. We also, for applicants to comply with Section 503 and VEVRA, we still have to provide that voluntary self-identification opportunity. So really the one kind of question is race and gender at the applicant stage. I think it's still legally permissible to do so. And many companies will have to comply with state or local requirements. Thoughts about employee resource groups, if all are invited. Again, absent future guidance from the administration around employee resource groups, I think if they are open to everyone and are not conferring certain benefits or privileges to individuals based on a protected characteristic, then I think that they are likely should pass muster. All right, I'm reading this one aloud. This has been the best webinar with very detailed information. Thank you. Some of the acronyms, sorry, yeah, it can be a little bit of word acronym soup here, alphabet soup. So I'm sorry if that got confusing. Feel free to email me. I am always happy to help provide some additional information on this. How was OFCCP established? Was it set up as a result of an act of Congress or was pursuant to an executive order? Woo. So it's a sub-agency within the U.S. Department of Labor. It wasn't an executive order, but I'm also not sure that it was an act of Congress. I think it was a regulatory development through the Department of Labor. But I'd have to research that. I don't know the answer to that off the top of my head. So we need to continue to complete annual AAPs, but only for individuals with a disability and protected veterans. That is correct. Is there a reliable source to better understand all the state AAP requirements? I wish. I have over the years cobbled together a resource that I just kind of use for internal purposes as kind of a just a cheat sheet and a checklist that I'm always trying to constantly update. So I'm happy to help with that as well. For private employers, there are some companies removing all references to DEI and removing the bio of their DEI VPs or managers. What are your thoughts on this? I think that is one of those things that is going to be unique to each individual organization, and every company is going to have to make their own decision around that. How some of it's risk tolerance, some of it's culture, some of it's waiting to understand what the government's going to do a little bit better. Auditing policies and public statements. Should this be done under privilege? Yeah, I think so. I mean, one, you want to get legal advice around those issues. So whether it's your in-house counsel doing that or you use outside counsel, I think the legal advice that you get would be covered under privilege. And I think it's definitely a good idea for that to do so. Here's a comment that Bloomberg does have a state-to-state comparison, but it requires a subscription. Yeah, good to know. There are definitely some platforms that provide good resources for comparing different state requirements, but it's usually just a starting point, and they're pretty generic for those purposes. I think that's about it. Again, feel free. I'll go back to the slide with my email. If we still have people on here. It looks like we still have a few. So thank you very much for joining us today. It was my pleasure. I hope it was helpful, and will continue to be a resource for you going forward. Take care.